Welcome to NCBA's Coffee Break. I'm your host, Nathan Willner, and today's guest is someone who I'm really excited to speak to. Jim McCarthy is a seasoned risk and compliance leader with over 30 years experience in the financial services area. Jim's career spans key roles at the FDIC, Penny Mac, served KPMG, and he holds a rare distinction of being one of the founding members of the CFPB, which I'm really looking forward to talking about. At the CFPB, Jim helped build the Bureau from the ground up, shaping consumer protections and regulatory oversight. Currently, Jim empowers institutions by navigating complex regulatory and other issues. I'm just really excited to hear his insights and the impact he makes on industry. So, with that, Jim, welcome.
Thank you, Nathan. It's great to be here.
I'm going to ask our listeners to grab their cup of coffee so we can dive right in.
Terrific.
All right. So, before we get into like a question or into a topic, give our audience a little bit of background. Like, how did you get from here to there?
Sure. So I guess the probably the most important thing to describe about my background is that it's long and it's been through many cycles of regulation and deregulation in what we call consumer financial products and services. So if you think back about the implementation of the Truth in Savings Act prior to the digitalization of our workplaces, that was a certain lift. And then you move forward to what we're seeing today in terms of the digital aspect of regulation. And going through those cycles has been very helpful to me. I've been in banking my entire career. And as you mentioned, spent some time at the regulators as well.
So, let's talk about the regulators because I don't know if you notice some stuff's going on in Washington these days. Uh, so, you've seen the CFPB evolve from this new kind of, innovative organization to this large behemoth, I'll call it, now being kind of pared down. What's the vibe now? Would you call the CFPB a watchdog group? Is it a collaborating agency? How would you describe what's going on over there today?
It probably falls somewhere in between, right? So I think, like you, it's very difficult for us to see what's really happening because even the sources that we have, our friends and our network that work inside the CFPB, don't have the full story either, right? So what I tend to do is I tend to look at what the fact pattern is, and the fact pattern is it still exists, and the rules under its purview still exist, and I encourage my clients and the industry to continue on with efforts, and then never quit monitoring the signals. A very aggressive plan for 2026 that was put out by the CFPB. I'm not sure how you staff that. And then we're seeing an open comment period for 1033, 1071 now with implementation dates. Seems like an aggressive posture with very little infrastructure, and that's confusing to me.
Hmm. Yeah, for business, the way people have always described it is the most important thing to business is not how many regulations there are or how much enforcement is. It's predictability, it's clarity. Knowing what to do and being able to do it properly is more important than how much you want us to do. Because if we're not clear about what you is required, it's very difficult to be, in line. So, and there's that kind of tension between the federal and state enforcement. I mean, from your days at the CFPB, did you hear that also a lot? That like, you're doing federal stuff and it's conflicting. Has that been an ongoing kind of theme uh, in that area?
When I was in the early days of the bureau, when I was there, we were very close with the other agencies, right? The OCC, the Fed, the FDIC, and just keep going down the line. And we worked very hard at making sure that we were providing support to the missions of those. Like we built what we called the regulator portal, which we'll talk about when maybe we get to the complaint space. What does that mean, right? That's a collaboration under an MOU with the FDIC or the OCC or the Federal Reserve that allows us to share data back in full jacket. So What is that infrastructure? Is it still operating today? And is it being dismantled? It seems like everything's flowing the way that it always has. I haven't seen MOUs be taken down. So the cooperation appears to still be there. It's that who's on the other side and who's running the other side is what the big question is. What is that cooperation doing?
Yeah, no, really good point. And you know, in a general sense, the CFPB's role is to protect consumers, to protecting, the population from consumer harm. What is consumer harm? And that's the problem. That is that a moving target, depending on who's in the White House or who's in the main office at the CFPB, so to speak. Have you seen that change over time of how you define that?
Well, I think that we're seeing it in a proposal that's open for public comment now, right? The redefinition of what they call risks to consumers under the rule, which will inform their any efforts they undertake in the non-bank space. And so I think it's very important to understand what that definition is and stress test your organization against that definition on a regular basis. Because unless that particular peg is sticking up, you're likely not going to see any attention. So, what is that peg and how do you monitor that on a regular basis?
Yeah, that's the trick. Now, something, Jim, that I wonder if you noticed, for lawyers, right, that we're supposed to be like sort of impartial. Some one day we could be representing the client on that side, next day the client on the other side. But for some reason in this space, we take things very personally. And you mentioned the complaint portal, and when it first was launched, a lot of my colleagues and people in this space were. The sky is falling. They were like very, very upset. These they were looking at them as sort of like being bullied online if they were on a social media platform by a bunch of people that are complaining. And there was, all kinds of reasons why they thought those complaints weren't accurate. You know, how can firms read the room when it comes to that complaint portal? Like, you know, are they taking it too personally?
Yeah. And I think that's a great question. And with this opportunity and the audience that you bring, I think it's important to get across one point, and we can address this when we have more time at a different time. But I will say, from a very educated perspective on this market, because that's all I focus on is complaints, um, is they are misunderstood. The definition of them is misunderstood. The value of them is misunderstood, and they're not leveraged in the way that they are. They're not leveraged externally with counsel or private enterprises the way that the regulator is leveraging them to find you quickly, right? There's a way to leverage that data that adds value to how the regulator scopes an examination and who it scopes it for. And what is that technique?
So, so give us an example of how a law firm who's doing debt collection could utilize, the data about complaints, whether it be in the space in a general sense or complaints made against the firm that they are working for. What would be a reasonable business savvy way to look at those things?
Sure. And I think the best thing to do is to start with understanding that complaints are sentiment, and especially with the CFPB, if we're talking CFPB complaints, which I believe the definition has been reverberated through the industry. It's a statement of dissatisfaction about a known company. So I fought vigorously not to attach the word complaint to these packets of information we were receiving from the public. I wanted a different word. And the reason I wanted a different word is because the entire infrastructure built by the CFPB doesn't support the definition of a complaint. It's not what we think of as a complaint. And for over a decade now, the industry has responded to this space as though they are complaints. When what's really happening inside the bureau or with my clients is we're looking at these from a hey, the customer said something sentiment perspective, right? And when there are millions of these, Is there any consistency or patterns that might be helpful to us? How often do you, as attorneys, get the opportunity to hear from millions of people at the same time to either support your argument or to give you an indication where there's harm and may need some assistance? And so looking at complaints as sentiment, looking at them appropriately as not the full answer, but an indicator to where harm could be, like the Consumer Financial Protection Bureau does, and making sure that you understand how to read complaints, right? So the product is always wrong, the issue is wrong. So how do you read those things?
Yeah, and again, perspective is important because it's. I always think to myself, the person that is writing, is taking this time to type something in, doesn't really understand what. Many times they don't understand who the CFPB even is,
Right.
and it's just many times it's just a request for clarity. I know that it's not uncommon for attorneys to occasionally get a grievance against them that uh, when they're doing debt collection litigation from a consumer, and the grievance will say they sued me and they got a judgment and now they're garnishing my wages.
Right.
Yep,
If you think,
that's not a grievance. That's just the fact.
right.
You know?
And another way to look at it, and you can expand from there, is think about it from one of our clients uses our system to run what we call forensics on data. Right, anytime the consumer says anything, we want to always run forensics on it, and we want to know and understand what's happening in the marketplace. Then comes along debanking, which we know is an issue today. We have our clients utilizing our technology to look for patterns of debanking. So the same way with the class action attorney in California that wants to know how often their call recording rules in California are broken. And so that's kind of how you leverage this data in the marketplace. It's very rich and supports a lot of the work that we do.
Yeah. So no, it's so great to put it in perspective to kind of look at it that this is the way the consumer's perception of what's going on. There might be some things in there that are being done wrong, but it just might be an educational issue, a process issue where you could actually use that information to not just raise your influence and your status in the industry, but also use it to actually increase your revenue. Because if you find out where these kinds of things are, so what's one compliance blind spot that keeps coming up over the years? Something that you kind of say, you need to get that right.
I don't know as if I have one. There are probably several. Um, I think that I don't like when we have problems with regulations interpretations. And I'll just tell you that there's a very large bucket of money out there that's fallen into this fraud bucket associated with Zelle and Venmo and Cash App. And there's a gap in Regulation E that says that's a friendly fraud or that's an approved transaction. Therefore, it's not a fraud covered under Reg E. I worry about not aggressively amending or at least addressing those problems in the regulation to help the marketplace understand what is an investigation, what is a covered transaction, what is this thing called friendly fraud. And so when we were at the Bureau and Eric Goldberg was working on Regulation E subpart B, the amount of work he did to understand everyone's opinion in the marketplace was astronomical. He was Superman in how he went out and conducted himself. And so I'd like to see some work done where regulations are obviously not helping us. The courts are having to interpret them. They're interpreting them differently. And that's really where I would like to see some work done.
So, this is just a cup of coffee, but we got the venti today. We got a tall one because we got a lot to talk about. But I just want to, as we're getting close to the end here, I want to ask you, there's a lot of talk about raising the definition of a large market participant to a higher number from 10 million to 25 million. Um, the question really this is this a time that, smaller players can fly under the radar, or were there still risks out there?
I think this is a time when smaller players can fly under the radar, but I think the if you look at the accounts receivable marketplace as an example, okay, when we first opened the our activities from the CFPB associated with Reg F and the rules with Reg F and the companies associated with that, there were thousands and thousands and thousands, many thousands of organizations. I know because I boarded them all onto the portal, right?
Hmm.
So post new rules, we saw that shrink dramatically. The players that are left are responsible, well-resourced players that I don't think are going to tolerate abuse in this market. Um, and I think the complaint space is really where we can monitor that. But I don't think the positive large players that are left in the marketplace are going to tolerate any kind of deterioration like we saw before. And that maybe is consistent across industries.
Interesting. Well, as we're ready to sign off, I'm going to give you the final word. So, what do you want to leave our listeners with today?
Be mindful of a very affordable data source and how to read it. And that's considered sentiment, both from the legal side as well as your client should be consuming this better as well.
Thank you, Jim, and thank you to our listeners. Hopefully, you'll have some time to come back because I have a lot more questions to ask you, and I think we're going to become very, very good friends over the next year because we have a lot to talk about. So thank you so much, and thank you to our listeners, and we'll see you back here on another episode of NCBA Coffee Break soon. Thanks, everyone. Have a great day.